that could help us focus on what it is that Hong Kong needs to do to be able to meet sort of this gold standard. So exploring sort of all of that, then we looked at how are different countries, what tools do they use to integrate these principles into practice, and that's where sort of the child rights impact assessment framework comes into play. There are several countries that have this tool and use it, not necessarily the jurisdictions that we've covered, but also other jurisdictions. So I looked at those and tried to compare sort of what are the questions or the issues that are covered by the framework, and then trying to distill what can we sort of develop that is Hong Kong specific, that would be of concern and of use. And the key factor for me was it has to be practically operationalizable, right? It has to be something that someone can look at and immediately sort of use to conduct an assessment that they're about to engage in. And of course, in order to do that, I'm not, as many of you know, I'm not in the fields that you're in. I have a distinct area of expertise, but we really need the tool to be workshopped with your input to test its practical sort of application. So Article 3 on the Convention of the Rights of the Child, as many of you know, requires that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, shall have the best interests of the child as a primary consideration, and that such that the protection and care as is necessary for children's well-being, accounting for their rights and duties, require that individuals who are in the care of children be held legally responsible for ensuring sort of these rights are holistically met. So there need to be legislative and other measures in play, including administrative measures, and that state parties should ensure that all institutions, services, facilities responsible for the care and protection of children conform with these international standards, particularly in the core areas outlined: safety, health, and ensure the suitability of their staff and competent supervision. States are under an obligation to take all necessary, deliberate, and concrete measures for the full implementation of this right. And the general comment number 14 of the committee has required the best interest assessment and determination of the issues to be applied in individual cases as well. So apart from sort of the macro level requirement that all laws and policies and administrative measures be developed keeping very much the best interests of the child at the heart of this process of developing these mechanisms, in individual cases, the state party is required to demonstrate that its administrators or those who are implementing these measures on the front line are using the best interest principle to assess and determine the outcomes in individual cases. So how should this article be implemented in practice? So they're drawing on various recommendations from different countries that we covered in the study. We can see that the CRC requires all areas of law policy affecting children to be covered. There's a full range there, including family and alternative care issues. There's a need for transparent criteria for courts and administrators and other frontline workers in assessing best interests. So the state has this obligation to develop the criteria, make them transparent, and ensure that all authorities are determining the best interests of the child in every area and giving it due weight as a primary consideration. And thirdly, the theme that we identified was that the CRC calls for the training of all individuals who are engaged in this work. If you're going to be in charge of administering different systems, then, and if the requirement is that the best interest principle be at the heart of it, then the individuals concerned necessarily need such training. So what can we learn then in terms of how the different jurisdictions have implemented the provision? There are various regulations that Norway discusses in its state party report to the UN. There's a Children's Act and various legislative amendments, etc. And particularly, they've also considered the interests of asylum-seeking children, recognizing that some children face particular marginalities which also need to be the subject of attention. And it's also got, it's incorporated the best interest of the child principle into its constitution, and has trained judges, and there's, of course, the Ombudsman for Children, which was the first ombudsman in the world to advocate for children and young people's rights, and it ensures that children participate in all of these processes. Yet, The concerns expressed by the committee in 2010 was that the primary consideration of the best interest principle of the best interest of the child is not yet applied in all areas affecting children. All areas affecting children. So it's not comprehensive, and those responsible for taking the children's best interest into account are not always sufficiently trained. And so it reiterated those requirements and identified areas where this principle could be further operationalized. I won't have time to go through the rest of the countries, but again, just to give you a sense, for Norway, for example, the committee reiterated that there be clear criteria and that this right be appropriately integrated and consistently interpreted, as Mikiko said earlier, and applied in all legislative, administrative, and judicial proceedings and decisions, as well as in all policies, programs, projects, and international cooperation relevant to and having an impact on children. So I'm now going to move to the Child Rights Impact Assessment Framework. So the Committee on the Rights of the Child, as has required that this principle be at the heart of our decisions. There are some variations in jurisdictions regarding whether the principle should be paramount, primary, or fundamental consideration, and that matters too, but we don't have time to go into that today. So what is the Child Rights Impact Assessment? UNICEF Canada says that a child rights impact assessment should be undertaken whenever there are new laws, policies, proposed legislation, regulations or budgets being adopted, or other administrative decisions at the national, provincial, territorial, or local levels. And so it's generally used more in consideration with treatment of children as a group, with an equity filter on specific groups of children rather than dealing with individual children themselves. And then it uses widely the framework of the CRC, and sometimes the countries which have adopted the optional protocol to the CRC, they would also sort of use those principles enshrined therein. So the idea is to ensure that the best interest principle is realizable. It's people or bodies who are working with children are held accountable, and it's to ask the right question to determine what is the impact, negative or positive, short-term or long-term, intended or unintended, direct or indirect on children, so that no child is left behind in the consideration of law and policy. So different jurisdictions have applied varying types of child rights impact assessments. The Flemish Parliament was the first jurisdiction which passed a law to require an impact report with regard to children, and all proposed laws were supposed to be screened through this framework in order to mitigate, and the obligation was to mitigate and avoid likely damage or damaging effects to children. And it also required the establishment of an expert commission on children to assist with this work. So again, we can see that while the measure at the top is important, we need sufficient and appropriate infrastructure and training to ensure that these principles are realizable in practice. Sweden has a model as well, but the CRIA has been applied only in certain contexts. So, for example, housing, building and planning, police, and the National Road Administration. It just goes to show that there's a whole array of areas where children may be the central or even just a peripheral consideration, but that still needs to be considered to ensure that the impact on them is not negative. The UK introduced a model as well, but it's only been applied 5 times since it was first established in the mid-2000s, and Scotland has its own. So this is sort of the potential for the CRIA to require that children be centered in any decision-making impacting them, and to ensure that there is sufficient data, information, and evidence to support decision-making so that it's grounded in some principle. And finally, it allows for the participation of children in these processes and also monitoring. I'm now going to jump to sort of the proposed framework I have, but I want to explain a little bit about it first. I've described a framework that has 3 different levels, which is contrary to what we see in international practice. In international practice, the CRIA is primarily for vetting or sort of consideration in the stage of proposing law or determining policy. So it's a macro level. So we have that. I've got a draft for that. It's a macro level policy and legislative development sort of accompanying tool, and it assesses this for its impact on children with as a group, right, as a distinct group. And then there are 2 further levels that I've identified. One is the meso level, looking at institutions. So this would allow, for example, schools or hospitals or NGOs who are working with children to start thinking about their sort of structure, their policies, and the way they do things, and how the impact of what is the impact of children on their impact on children of their work, regardless of whether children are the sort of their direct sort of recipients of a service, or whether they're peripheral subjects. So, for example, a shelter may be primarily directed at women seeking shelter from abuse, but then those with children accompanying them also have to have their needs looked after and ensure that they are safe and provided for. So, in that sense, the shelter could use this meso-level framework to assess that rights and needs of children are properly taken care of. And lastly, and the most important one that I want to sort of workshop and float with you today, is the micro-level framework, which is a decision-making model that requires an individual who has a case before him or her to work through the different stages of the framework to ensure that they have holistically considered the impact of a proposed intervention or the impact of deciding not to take any action at this particular time. And that's one of the challenges, I think, in Hong Kong, that sometimes practitioners disagree on whether it's time to jump in and do something, and whether there are sufficient triggers to do so. So this framework allows frontline responders to think about what are the next steps for me to consider. What are the basis for my decision to decide not to do anything at this particular time, right? So it's sort of a triaging process as well. You can put something on an alert level, you'll think about it and come back to it. You identify a time frame within which you must come back and review your decision. You document what you've observed which led you to be concerned in the first place. And then at what point do you escalate the case so that you put it on a watch list, or you make relevant referrals to find out more information, or you take immediate and urgent action to ensure that the child is protected against harm or impending harm. And so I think that the tool has a multi-dimensional perspective, and it's overlapping the three levels, the macro, the meso, and the micro, and it enables cross-industry experts to start to develop a shared language around the considerations. The challenge, of course, is that at this, in its current form, it's very sort of, it's based in sort of legal terms and legal provisions. But obviously, ultimately, the goal is for it to be something that different, professionals and organizations can use and sort of upscale with their own sort of language, so that they can determine the relevance of the terminology and whether it sort of means what they need it to mean in order to secure sort of the holistic protection of the child in light of their rights and interests. And the objective really is that when we're conducting child rights assessments, children often fall through the gaps when a particular frontline person hasn't thought of a potential risk or a threat. And that's where sort of that space between realizing that I should have thought of this and sort of the child then being left with a particular care professional or not in any care professional, that's the space in which sort of tragedy occurs. And so the goal is not to use the tool as an off-the-shelf kit, but rather to continuously adapt and refine it to determine the specific sort of needs of cases that you handle. So in the workshop yesterday, we discussed with various organizations, and for example, the hypothetical we were talking about were teenage pregnant girls. And so an NGO working on those issues could develop a very specific tool that would be helpful for their specific work with this target group of children, but also they could refine it further to apply to individual girls coming in and do an intake assessment on the spot. So the question is, how can such assessments be conducted in a consistent manner, and how can different industry professionals learn from each other about the value of such assessments and agree with each other that once we've got 3 or 4 sort of red alert level factors, risk factors present in a particular case, then the case must be escalated and there's no time to sort of sit and watch. So this helps to put children right at the center. It focuses on prevention and protection against harm and puts the best interests of children right at the heart of it on a day-to-day sort of case management basis. And it recognizes children as they are. right? And the framework also identifies the spaces for children to be heard. So their voice should also be heard, their views should be elicited and acknowledged, and then any proposals for intervention be designed accordingly. So there's a lot there that I'll be sharing once this sort of goes live online, but I don't have time to get into it for the moment. But just to sort of summarize, it's a guiding framework, it's adaptable, it's subject to being refined for industry-specific professionals, it's to be applied regularly to assess impact on individual children or children working with an institution or at an institution, and then at the macro level for the development of law and policy on a regular basis. And this then material should serve as a basis for collecting data and examining it, analyzing it from a distance when those cases have passed, and then again going back to the drawing board to further refine the framework to ensure that it's in tune with the kind of cases that are coming before sort of the different institutions and bodies. I just want to say a final word. The framework is general, but it does ask the practitioner to focus also on sort of the whether the child comes from a marginalized or disadvantaged group. And I just want to highlight that, of course, as you're all aware, there are gender, race, religion, poverty, disability, sexuality, all of these different dimensions which might be affecting the context in which the child is situated or inherent in the child itself or themselves. And then there will be supplementary considerations that are triggered in light of those distinct interests. And of course, to further complicate the picture, you may have one child which carries, these multiple dimensions of complexity that also need to be handled, but which are very important to recognize because of the risk of harm that are attendant on children of this particular background. So just drawing on what Mr. Cross said, for cyberbullying, for example, the research done by Hong Kong Union Polytechnic reveals that children in families where family violence is an issue are more likely to be the subject of online bullying. Knowing that nexus allows us then to develop much more specific and targeted interventions that can help children in those situations. So I want to leave this for you to think about. What is the role and relevance of such impact assessment frameworks in the work that you're doing? What are some of the resources that are needed to make this happen? Of course, there's a need for training and workshopping. And also, what are some of the challenges that this tool can sort of help address, but also the challenges that come with using a tool like this? Thank you so much.
Thank you, Professor Kapai, and please remain on stage. So now we have already heard from some of our very inspiring speakers this morning, and I'm sure some of you may have questions for them. So hence, can I also invite Professor Cross, Ms. Block, and Ms. Otani back on stage so that we can have an open discussion session. So if you have any question that you would like to ask them, please raise your hand and our staff will pass the mic to you.
Testing. I wanted to thank also the latest two plenary speakers for sharing their expertise and their insights and these thoughtful remarks, and especially Professor Cross, thank you for highlighting and providing this overview of children's rights issues, but also highlighting the gaps and challenges that still exist in laws and policies, and calling the new Children's Commission to action, which I think is also really good. And Professor Kupai, thank you for sharing your research and highlighting this assessment tool to make sure that policies are more holistic, inclusive, and really speak to including children's rights and children themselves. So we have some time for questions. In case anybody's interested to ask one of the panelists a question, please raise your hands and someone will get to you. I'll take questions in sets of two, so if some of the other mics can go to this gentleman and that lady, and please state your name and introduce yourself. Just speak into
Good morning. I'd like to ask Ms. Otani a question about the work of the committee, because the answers that you are given by governments, and perhaps I'm most familiar with the kind of answers that the Hong Kong government puts up when it comes before any of the relevant governing or supervising bodies for human rights instruments. what you will get, and of course I fully understand the need to be polite to governments because you need to exercise persuasion rather than calling them out and pointing out that actually they're lying to you. But let me tell you one thing about specifically the Convention on the Rights of the Child. The official legal position taken by the government in court cases is that, of course, it's not legally binding, all right? And that has a huge impact on government policies. It has a huge impact on the day-to-day lives of families, and it has a huge impact when one wants to come before the court and argue exactly what Pujai has been talking about, that where a decision impacts on a child, there is at least a legal obligation to take the interests of the child into account. Not a revolutionary idea, you would think, but it seems to be legally revolutionary, and we'll find out by probably the end of November whether our Court of Final Appeal has any interest whatsoever in addressing this point. Because unless the committee says, all right, if you take the approach that the convention is not legally binding, then jolly well get your skates on and introduce legislation to implement measures to make sure that in decisions that impact on the child, every agency of government has got an obligation to take the interests of the child into consideration. Because they will duck and they will weave and they'll say, well, this does not directly concern the child. It may affect the child, but we've got no legal obligation, full stop. All right? Can I just perhaps raise some other question about Pujai's point about imbalance, that certain decisions clearly impact, and policy decisions impact most on the poorer sector of society. In litigation, of course, there is a complete imbalance of resources when one is challenging government policies. Government has all the access to the information. It has all the access to statistics, whatever they need to put up to counter. And the individual litigant is always at a disadvantage. If you're on legal aid, you're not going to get an expert instructed. You're not going to get the information from the government that you need to fight this case properly. So there's a complete imbalance of resources, which impacts ultimately on decision. And I just wondered whether in formulating this particular conference, there was any consideration given to inviting the judiciary to come and give its view on the Convention on the Rights of the Child and how they see it. And whether they accept in supervising decision-making and policy-making by the government, which does come up in judicial review, whether they see that they have a role to play, which they could play through introducing, through the common law, which they can develop in Hong Kong, even if the government says we don't have a legal obligation. Finally, I'd just like to say whether there has been any research done on whether people who have themselves been subject to abuse as a child, when they become a parent, are more likely to abuse their children, and also whether domestic violence between parents can also have a very negative psychological impact on children. I'm sorry to flood you with questions, but everything that I've raised, I think, are very, very important issues in Hong Kong right now.
Thank you so much. I'll just go to this gentleman, and then please keep your question brief.
Yes, I'm Jackie Lai, counsel, family mediator. I have a question towards Professor Cross and Professor Kapai. You talk about gold standard, CRIA at macro and micro level, and Professor Cross, you talk about Cinderella's law, UK. Yeah, I suspect I want to focus my questions on the resources part. Now, in UK, if we follow UK's steps in getting this Cinderella's law, I suspect that we should have enough resources regarding, say, clinical psychologists, psychiatrists, to enforce the Cinderella's law. I bet in tracking the sex offenders by administrative means, immigration department, or electronic tracking, technological means, may be simpler. But I want professors, you can comment on the resources, say, UK vis-a-vis Hong Kong, and how to getting this gold standard, and how to follow the, say, if we have the Cinderella's law. That's my question. Thank you.
Thank you so much. Should I start maybe with Ms. Otani to respond to the legally binding question?
Thank you very much. Interestingly, that your first question is also a very serious matter in Japan. And at this moment, just as my personal research project, I am doing the research on the what are the remedies for the children, and I'm looking into all the international human rights treaties, how the remedies are provided in the international human rights treaties, and also how each international human rights treaty body has addressed the issue of the right to remedy when the rights are violated. Actually, as a lawyer, of course, our work as a lawyer is more for the remedy side, but I am personally more interested in prevention side. However, I have seen in the Convention on the Rights of the Child, there is no explicit provision on the right to remedy. In Article 4, the implementation measures obligations do not specifically talk about the right to remedy, unlike the Article 2 of the International Covenant on Civil Political Rights. And what I have found, for example, CEDAW, the Committee on the Elimination of All Forms of Discrimination Against Women, although the CEDAW Convention either does not have the specific article which talks about right to remedy, but still this committee always asks the state parties, what is the status of this convention in your domestic legal system? Because they believe that this is the first question. If there is a discrimination, the victim goes to the court and claims the application of the convention. So it has to be legally binding. Otherwise, it has to be backed up by the specific legislation. So they always ask, and they ask in more detail, like even if the state party says that, yes, it has a legal force in the domestic law, is that directly applicable? And compared to other human rights treaty bodies, in particular CEDAW committee, I have found that my committee, the Committee on the Rights of the Child, has not paid so much or enough attention to these very, very fundamental questions, very relevant, not only for the remedies after the violation actually happened, but also to guide all the governments to think about this is legally binding in our legal system. So I think your first question is very important, and recently, based on my own research, I'm now feeling that our committee should look more into the details of each state's situation and what are the challenges in terms of the legal binding status of this convention. So thank you very much. And second question, you mentioned about imbalance. Yes, and again, I think this is so important. And when we received the state parties report, this is the report about the situation as a nation or as a country. But as Pooja mentioned briefly about the no one shall be left behind, no child shall be left behind, as we know all from the SDGs, we need to look into the more individual situations. Sometimes some groups are particularly affected or vulnerable, and poverty means a lot. And in terms of the legal remedy, as you mentioned, it affects. So we are now more and more looking into the more detailed local imbalance or imbalance among some groups, of course, boys and girls, and in some particular situations. And I think this is what we are also concerned, and we should do more. Thank you very much. And the third question is, I think somebody can answer more, but our knowledge, based on some scientific research, shows that if they experience the violence in their childhood, it might affect his or her later stage of the life. Even the existence of domestic violence between the parents, not necessarily against the child itself.
Thank you. I have a mic. Thank you. Okay. Thank you so much, Gladys, for the very pertinent question. So first, I'll just say on the committee, reporting to the committee, although the government does take the position perhaps in courts that it is not legally binding because the convention hasn't been incorporated, with the recent experience with the third committee hearing, the government is saying that although the RDO doesn't expressly cover government functions and powers, it says that the government is still bound by the race convention, and then it proceeds to outline how the basic law has a provision on equality and the Bill of Rights ordinance. So, you know, I think that it's still not made up its mind, and it says different things in different contexts. So the NGOs, I think, play a very big role in alerting the civil society to sort of counter those claims that it does make at the committee level. And I think on that, in terms of the imbalance, we see that the government does provide some statistics to the committee, but the committee also takes the information provided by NGOs very seriously. And this is really why I'm urging a call for practitioners to do more documenting and do more case discussion, because we can start to develop our own statistics, because we're not going to get them anytime soon. And then we can start identifying patterns. It may just be half the picture, but we're starting to fill out a picture. In terms of involving judges, yes, I'm happy to talk to you about it. It's phase 2. Where we want to talk about specifically the legal provisions, the impact, the jurisprudence, and all of that. So we can certainly talk about that. I do agree with you. The judges have a very important role in pushing government to go where it is reluctant to go. Has there been research done on children? Yes, there is established research internationally and also in Hong Kong that intergenerational cycles of violence are continual, and they're very detrimental to various aspects of relationship formation and rights protection. And there's also a phenomenon called polyvictimization, which is exactly what you described. When children witness domestic violence, they are also very deeply affected in their life. So there is research which is Hong Kong specific. On resources, you know, how do you get to the gold standard? I think we have to start earlier in the training of all the professionals to highlight what their own individual role and responsibility is, because all of us are surrounding children all the time, but we don't see it as our job. Hong Kong has this tendency that this work is for the social worker, this is for the teacher, I'm not going to do this, I don't have the time, but I think we have to inculcate a different sense of accountability. And again, the framework forces us, because we have to have an answer. If we decided to pass it on, what was our consideration? What is the basis that allowed us to say, I'm going to let it go, this organization is going to deal with it? And the other very important point is, what is our follow-up protocol? If we've left a case to someone else, what is the extent of our duty or obligation to make sure that it's seen through? Because anybody can drop the ball, but we don't have structures in place to allow that kind of monitoring. And government budgeting is key. What resources government is willing to allocate to rights implementation says a lot about their degree of commitment. So I think we also have to lobby at that level.
Well, I would agree with that, obviously. Whenever new criminal laws are introduced, there are financial implications, resource implications. When, for example, I discussed the new evidential arrangements which were introduced in the 1990s for taking evidence from children prior to trial and for taking video recordings from children and so on. These had resource implications, and the police had to develop a specialized team, which I think is now called the Child Policy Protection Unit, of specialized experts who knew how to interview children in advance and knew how to take video recordings which would be acceptable to the courts when the trials eventually took place. So, and again, when the child pornography ordinance was introduced some years ago, there were doubtless implications to that. I identified two main areas in my remarks earlier on. One involves the criminalization of the situation where someone knows there's a risk towards a child but does nothing about it, or just ignores it, or allows it to continue. That wouldn't involve any great financial implication, in my view, because that's the sort of matter which the police would be able to absorb into their normal investigatory duties. It would be a matter of a police officer examining the facts and constructing a case. As regards my other proposal, that the child cruelty law be expanded to cover emotional and psychological abuse, well, obviously psychologists would have to undertake assessments of the children. I don't know exactly how many psychologists are available, child psychologists are available at the moment, and it may be there would have to be an increase, but I wouldn't imagine it would be a huge one.
So thank you all so much for your remarks and your thoughts. I realize there might have been, these morning discussions might have inspired a lot of further questions and discussions, and I would invite you to speak to the panelists during breaks and during the lunch. And unfortunately, we have to wrap up this open discussion, but thank you all for engaging, and thank you all so much for your remarks.
Thank you.
Thank you, everyone, especially the enthusiastic response from the audience. And we'll now take a short break, a 5-minute break, and I'll see you guys later.
It's easily done. I nearly did it too. I nearly fell as well. Yes.